position in the Supreme Court has committed acts tantamount to betrayal of public trust that would warrant the removal from office. It is all the more difficult for me because I took my oath before this man. If this were a purely legal process, my legal training would require that much of the evidence presented is disregarded due to irregularities in obtaining the same. But this is not a purely legal process. The framers of the Constitution did not set the quantum of evidence nor the burden of proof required to convict. Much was left to the individual conscience and the collective wisdom of the Senate. Further, impeachment cases are heard by senator judges with different professional backgrounds. Of the 23 senator judges, less than half of us are lawyers. Thus, I was challenged and admittedly burdened by the need to balance my legal training as a lawyer and my calling as a public servant, particularly a senator judge. The Chief Justice states that the requirement in the Constitution to declare one's assets, liabilities, and net worth is as may be required by law. He then cites Republic Act 6426, or the Foreign Currency Deposit Act, as that law, which states that dollar deposits are absolutely confidential, thus providing him with a shield. Is that the law in point? Is that the law that the Constitution stated will be required by law? I submit it is not. It is Republic Act 6713, the Code of Conduct and Ethical Standards for Public Officials and Employees, which, among others, requires the submission of a statement of assets and liabilities and provides the details thereof. It requires stating all kinds of assets, including cash on hand and in banks. There are no exceptions. To allow the contrary view would be setting a deadly precedent. It would allow any official to hide his assets behind the cloak of the Foreign Currency Deposit Act. Does that make sense? It does not, both from a legal point of view and from a lay person's view. Bakit pwedeng itago ang pera sa dolyar? Makatarungan ba yun? Republic Act 6426 on the secrecy of foreign currency deposit is not an exception to the law requiring the declaration of the SALN. In fact, it is easy to reconcile the same. A government official should declare his assets and liabilities, but then no one can examine the bank account without his written consent. The defense then posits the view that misdeclaration in the SALN is minor and therefore not an impeachable offense compared to other impeachable offenses like bribery and treason. As a lawyer, to me, minor inaccuracies in the SALN, such as parking lots or a unit whose ownership is under contention, would not amount to betrayal of public trust. In fact, corrections are allowed under the law, but the failure to declare $2.4 million and some 80 million pesos is not minor. In decided cases, the Supreme Court has ordered the dismissal from service of public officials and employees for failure to declare a sari-sari store, 2 motor vehicles, and for non-declaration of several assets such as real property and bank deposits. These are the cases of Rabe versus Delsa Flores, Ombudsman versus Nieto, Racho Flores versus Montemayor. I also have difficulty accepting the defense of commingled funds. Yes, the fact of commingling of funds, I believe, is common among families. But the huge amounts involved leads much doubt in my mind. In our interpretation of the law, we who hold a position of public trust must choose the interpretation that will uphold public interest over private interest, regardless of whether malice or an intent to suppress the truth was present. We must remember that public office is a public trust. Once the trust is gone, we must step down to preserve the integrity of the position we hold. Pag nawala po ang tiwala ng taong bayan, dapat po bumaba na sa pwesto. Dapat po pangalagaan ang posisyon na yon. Lastly, we need to remember that we can only mature as a democracy if we can learn from this impeachment experience. From the start, I questioned breaches in procedural law and ethical conduct of various participants in the impeachment process. The trial by publicity, the irresponsible hurling of bloated, unverified figures and assets, among others. My fervent hope is in the future, the pursuit of justice will be conducted in a more responsible manner, lest our children are left with the impression that those accused of wrongdoing can be persecuted without respecting their rights. The other lesson must go beyond the Chief Justice. It is the call for transparency. I echo that call. Those of us who sit as judges, those of us who act as prosecutors, and all those in public service should not hide behind our titles. We must come clean and give meaning to the constitutional requirement that we declare all our assets. Mr. President, on the accusation made in Article 2, I find the respondent guilty.
Honorable Senator Judge Defensor Santiago.
The Constitution provides that in all criminal prosecutions, the accused shall be